Welcome to Details of Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals navigating separation and divorce. So, whether you're concerned about asset division, protecting your business, or dealing with foreign property disputes, we're here to provide clear, practical insights. Now, divorce is complex, but understanding your rights and options can make all the difference in the world. And while this isn't legal advice, it is designed to empower you with the knowledge you need to move forward with confidence. When couples walk down the aisle, they're not just making romantic vows, they're entering into one of the most significant financial partnerships of their lives. While popular culture celebrates marriage as a union of hearts, the law recognizes it as something equally important: a binding economic arrangement with enforceable obligations, measurable contributions, and predictable financial consequences. Marriage as economic partnership. That's what we're talking about today. And what the law says, Ontario's Family Law Act, in fact, doesn't mince words about the economic nature of marriage. Section 5.7 explicitly states that childcare, household management, and financial provisions are the joint responsibilities of the spouses and recognizes equal contribution, whether financial or otherwise, within the marital relationship. This is not poetic language. It's the statutory foundation for how property and wealth are divided when marriages come to an end. Marriage in law isn't a partnership in the commercial sense under the Partnership Act, but it operates as an economic partnership in policy and effect. Whether one spouse earns income while the other manages the household, or both pursue careers while juggling domestic duties, the Family Law Act presumes equal contribution to the family's economic success. The equalization payment, at the heart of Ontario's approach to marital property, is the concept of the net family property, essentially meaning the value of what each spouse owns at separation minus what they brought into the marriage, with some exclusions. Under the Family Law Act, Section 5.1, when a marriage ends by divorce, annulment, or separation without reconciliation, the spouse with the lesser net family property is entitled to one half of the difference between the two amounts. Now, think of it this way. If one spouse's net family property is $800,000 and the other's is $200,000, the latter is entitled to an equalization payment of $300,000. This isn't a gift or discretionary award. It's the statutory right born from the recognition that both spouses contributed equally to building that wealth, regardless of whose name appears on the assets. Now, here's a real-world example you may be familiar with: the Bezos settlement. When Jeff and Mackenzie Bezos divorced in 2019, she received approximately $38 billion in Amazon stock. Washington's community property regime entitled her to half of marital assets, recognizing her domestic and family contributions. While Ontario uses an equalization model rather than direct division, the underlying principle is similar. Mackenzie's contribution as a spouse supporting Jeff while he built Amazon, raising their 4 children, and managing their household were recognized as equal to his business building efforts. Each spouse is presumed to have contributed equally to the accumulation of wealth during the marriage. Under Ontario's Family Law Act, the result would be comparable through net family property equalization, with Mackenzie entitled to half the difference in their accumulated wealth during the marriage. Now, certain properties are excluded, such as gifts and inheritances, unless they become part of the matrimonial home. Personal injury damages also, and insurance proceeds as well. Those are excluded. The burden of proving an exclusion rests with the spouse claiming it, and that's also according to the Family Law Act as well. Beyond ownership, the constructive trust, sometimes legal title doesn't tell the full story. The Supreme Court of Canada confirmed in Rawlock v. Rawlock that Ontario's property equalization scheme doesn't eliminate equitable remedies like the Constructive Trust. When Jacqueline Rawluck dedicated years to operating the family farm and business alongside her husband, despite all properties being registered in his name, the court recognized her beneficial ownership through a constructive trust. This gave her not just a share of the value at separation, but actual ownership interest, allowing her to participate in the property's appreciation after separation. Importantly, Rawluck held that equitable remedies can supplement the statutory scheme, but should not duplicate it. Later, in the case of Peter v. Bedlow, which was a 1993 case, the court clarified that constructive trust can arise when one party is unjustly enriched by the other's contributions. The message here is clear. Contributions do matter, even when they're not reflected in legal documents. As the court noted, property under the Family Law Act includes beneficial ownership, and courts can recognize contributions, financial or otherwise, to acquiring or maintaining property. Even for unmarried couples, Ontario courts recognize that domestic partnerships often constitutes joint family ventures. The landmark case in Kerr v. Baranow established that one partner's assumption of domestic responsibilities and childcare directly enables the other's wealth accumulation. The contributing partner may be entitled to a proportionate share of that wealth. Smart business partners document their arrangement before problems arise. Similarly, domestic contracts, including prenuptial and cohabitation agreements, allow couples to define their financial relationships on their own terms, potentially contracting out of property equalization or spousal support obligations. However, these agreements aren't bulletproof. Courts can set aside domestic contracts when a party failed to disclose significant assets or debts, a party didn't understand the agreement's nature and consequences, often requiring independent legal advice, the agreement produces unconscionable results, and support provisions create unreasonable hardships or leave someone dependent on social assistance. In Levan v. Levan, a 2008 Court of Appeal case, the court set aside a marriage contract due to inadequate disclosure and lack of informed consent. Similarly, the Divorce Act and Family Law Act allow variation of support provisions if enforcing them would cause undue hardship. In terms of a real-world example, the Dr. Dre prenup challenge is famous. Music mogul Dr. Dre and his ex-wife Nicole Young, in 2021, they divorced, and that divorce highlighted the limits of prenuptial agreements. Despite signing a prenup in 1996, Young challenged its validity, claiming that Dre tore it up early in their marriage. She ultimately received a reported $100 million settlement after 24 years of marriage. The case underscores a crucial lesson for Ontario couples. Prenups can be challenged and set aside if there's evidence of duress, lack of disclosure, or subsequent agreements, even informal ones, to void the contract. Under Ontario's Family Law Act, courts scrutinize domestic contracts particularly carefully when one party claims they didn't understand the agreement's consequences or lacked independent legal advice, factors allegedly that were present in Young's case. The lesson: domestic contracts provide valuable protection, but only when properly drafted with full financial disclosure and independent legal counsel. And even then, circumstances can change their enforceability. For entrepreneurs, marriage can intertwine business growth with family law risk. Under the Family Law Act, Section 9(1), courts can order the transfer of business shares or property to satisfy an equalization payment. The case of Sarah v. Sarah, 2009 Ontario Court of Appeal case shows the stakes. A textile business's post-separation collapse significantly affected equalization because the valuation date anchored the spouse's entitlement despite later market shifts. In the case of Bill and Melinda Gates, a famous case, as those two announced their divorce in 2021 after 27 years of marriage. Observers wondered how their vast fortune, including significant Microsoft holdings and the Gates Foundation, would be divided. Now, while details remain private, the couple likely had to have had sophisticated domestic contracts and corporate structures in place. However, without such planning, a business owner in Ontario, for example, faces similar risks. If you build a company worth $100 million during your marriage, your spouse may in fact be entitled to an equalization payment of $50 million, potentially forcing a sale or restructuring of the business. The Gates case illustrates why successful entrepreneurs need comprehensive legal strategies, including prenuptial agreements, family trusts, and corporate holdings to protect business continuity while respecting their spouse's legitimate economic interest in marital wealth accumulation. Without proper planning through domestic contracts, corporate structure, or estate freezes, business owners may face liquidity crisis or forced sales when marriages come to an end. The business you built might be yours in name, but matrimonial law gives your spouse claim to half its growth during the marriage. The most successful business partnerships thrive on transparency, foresight, and clear expectations, and so do marriages. Before marrying, here's what you should do. Understand your legal framework. Know Ontario's rules on property and support. Disclose fully. Be honest about assets, debt, and financial goals. Consider a domestic contract, especially if you own a business or expect an inheritance. And number one, seek independent legal advice always. Also review periodically. Life changes, your agreements, they also need to be re-examined over time. The conclusion here is love and ledgers, they go together sometimes. Recognizing marriage as an economic partnership doesn't diminish the emotional significance. It simply acknowledges reality. Ontario law has evolved to ensure that when marriages end, the financial consequences reflect both parties' contributions to building shared wealth and maintaining the family unit. Whether you're contemplating marriage, currently married, or facing separation, understanding the business of marriage empowers you to make informed decisions, protect your interests, and plan effectively for whatever the future may hold. Wealth doesn't insulate anyone from legal principles. It only raises the stakes. After all, the best time to think about the end of a partnership is at the beginning, when goodwill prevails and rational planning is still possible. Well, that's it for this episode in Details in Divorce. We hope you found today's discussion insightful and valuable as you navigate your own divorce journey. Remember, every situation is unique, and getting the right information is key to making the best decisions for your future. If you have any questions or need guidance, the Riley Firm is here to help. Be sure to subscribe so you don't miss our upcoming episodes, where we continue to explore the critical issues that matter most during divorce. I'll see you next time.